Did you know that more than 60% of American adults do not have essential legal documents like powers of attorney in place, according to the AARP? Planning for the future, whether it's property, inheritance, or caring for vulnerable loved ones, is something we often put off until it's too late. And joining us about how to share the staggering, devastating statistics that could cause family and how you can prevent it from happening to you, Shelby County Probate Court Division I Judge Kathleen Gomes here to tell us. Thank you so much for coming in.
Thank you. You know, I'm always glad to give an opportunity to educate. I wanted to talk about powers of attorney because I know that if you ever go to the doctor or even a hospital, they say, do you have powers of attorney? So let me explain. There are two kinds of powers of attorney. One is a power of attorney over your money, which is called a durable power of attorney. The second one is a power of attorney over your health care. So in theory, if you have both of these documents in place, should something happen to you, should you become disabled, should you have some infirmity or accident or something, then someone can act in your place and they can pay your bills as well as make medical decisions. Now, remember, however, that the power of attorney is what we call a fiduciary relationship. And so as a fiduciary, you're only supposed to act on the benefit or for the benefit of that individual. So you're not supposed to use that power of attorney to benefit yourself.
Right, like taking money.
Exactly, like going to the bank and using your power of attorney to get all the money into your account, or using your power of attorney to transfer real estate into your name alone, or using your power of attorney to become either a paid-on death beneficiary or a joint owner. Now, the banks don't regulate that. So what usually happens is when I see it, it's because somebody, after they die, we find out that one of the relatives using the power of attorney has basically become the beneficiary of all the funds. It is a revocable document, which means that you can change it anytime you want to. Where we have run into a problem, however, is because it is revocable, some of our vulnerable individuals have revoked it numerous times. So I had an individual not too long ago that had basically, after his mother died, and he was a vulnerable individual, he got 5 different members of the family to get him to sign powers of attorney. And it wasn't until it came to me, because it was like, you know, each one of them took a little bit more. So it's an important document, but once again, it can be abused. But we recommend it because it's the way that we really try to avoid having a conservatorship. You know, I've talked before about trust. You should only appoint someone as your power of attorney that you trust to make those decisions. The law presumes that if you have used that power of attorney to benefit yourself, there's a presumption of undue influence. So it's a serious document.
What's the worst thing you've seen with someone who didn't quite have this in place?
Well, they end up in the conservatorship. I mean, we as lawyers, when we're trying to do estate planning and things like that, we tell individuals, well, here's how you avoid having a conservatorship, is that you need a power of attorney for health care and a durable power of attorney. However, you know, those can be changed too, but that's the idea, is to keep you from having to have a conservatorship.
Wow.
But once again, since it is a revocable document, you can still be taken advantage of from other people.
Like Britney Spears. Well, allegedly. And so, allegedly. So wait, I mean, talk to me about just when you should draw this up, because people tend to do it later in life.
Well, I mean, you should do it now. I mean, honestly.
When you're 18?
Absolutely. As a matter of fact, some people are doing it when their kids go off to college. Because if they're 18 years old, you're not going to be able to speak on their behalf. So a lot of people are doing it when their kids turn age 18 so that they can, you know, be able to handle things should they something happen in school. Because the thing is that it doesn't necessarily mean that you are totally demented or anything like that when you need the power of attorney. It can be that you've had an automobile accident and you're unable to make decisions as to your health care, you see. So it can be, it's a useful document, but the idea is that you only use it when it's necessary, not just to benefit yourself.
And what rights do you have? I mean, if you're vulnerable, then, you know, how are you going to enforce your rights? But what rights are there, and what should people do if they suspect this is happening?
Well, of course, that's where it ends up in my court.
Yeah.
The thing is that someone would have to bring it to my attention, all right, to the probate court's attention. And sometimes the person who is taking advantage of that individual is not going to bring it to my attention. It's going to be someone later on. But we've had just horror stories of people taking advantage. And usually, you remember that usually you appoint a relative as your power of attorney, but sometimes people appoint their caregivers because they have nobody else.
Wow. I mean, this is a really tough one. And you're in probate court, and, you know, we just appreciate you taking time to just educate the public about this.
I think it's my job. Honestly, I think it's my job. And actually, the last time I was here, several people contacted me to speak at various organizations because I think it is the role of me and judges like me to educate.
All right. Thank you, Judge Kathleen Gomes. Really appreciate your time, and thank you so much for joining Live at 9.
Thank you.